back around 1998, Gibson sued PRS over PRS's single-cut guitar. Around 1987 or 1988, Gibson applied for a trademark for the silhouette of the Les Paul body. About a decade later, that trademark became what's called incontestable. In other words, it belongs to Gibson. PRS was selling the single-cut guitar. Gibson sent a cease and desist letter saying, "Stop selling it, that's our design." And PRS pretty much told them to go pound sand. Gibson did what Gibson does, and that is hailed PRS into court. They sued, I believe it was in Nashville, which is the Fifth Circuit. Now, as I stated in the Gibson versus Dean case, that one was out of the Sixth Circuit. And the reason that's important is those are different circuits, and that's part of the reason why the PRS case really isn't overly controlling on the Dean case. But that's something for another video. Now, in this case, Gibson sued PRS over specifically trademark infringement, counterfeiting, false designation of origin, and dilution under the Lanham Act. Now, dilution under the Lanham Act basically says you're ruining the value of our trademark. You're diluting its value. Now, PRS, they counterclaimed. Now, a counterclaim, as I've explained, it's kind of like a boxing match. Imagine Mike Tyson versus Evander Holyfield. Mike Tyson punches Evander Holyfield. Holyfield counters. That's what it is. It's a counterclaim. So PRS punched back. And what they did is they said, that trademark, it's invalid. It's no good. So just invalidate it, make it unenforceable. And they also wanted a ruling saying that Gibson's trademarks weren't infringed and that any what's called trade dress associated with the Les Paul was not protectable, and that if it was, the single cut doesn't infringe on it. Now, there's a legal term in there, and that's called trade dress. Now, trade dress is a color or a shape, something that is inextricably linked to a specific brand. There are two trade dress colors that come to mind, specifically Robin's Egg Blue for Tiffany and Company, and pink for Owen Corning insulation. Those are trade dress, and that's why the only company that can sell pink insulation is Owen Corning, and the only jeweler that can use that Robin's Egg Blue is Tiffany and Company. It belongs to them. It is part of their trade dress. The original iMac design, going all the way back to 2001, that was trade dress. There was actually a case involving that. However, that isn't relevant here. Here, the trade dress involved was the shape of the Les Paul guitar. One of the things that was stipulated at the beginning was that PRS manufactured high-quality guitars. It sounds like a little nitpick, but it actually comes into play in the ruling. Now, what Gibson said basically is this. They said people who go to the store are going to go and they're going to buy a PRS thinking it's a Gibson, or they'll see someone playing a PRS and they'll think it's a Gibson. There would be confusion, and because of that confusion, Gibson would be harmed. Now, it was a really curious argument, specifically what was called the smoky bar scenario. Now, the smoky bar scenario, that was actually what it's called, and it was Gibson's argument, and it went out like this. Imagine, if you will, that there is a budding guitarist who goes out to a smoky bar to see a blues guitarist. That blues guitarist is playing a PRS single cut. However, because it's a smoky bar, it's not overly clear whether it's a PRS or a Gibson. And as such, that budding musician goes on down to the local guitar store and wants to buy the same guitar. Unbeknownst to him, he picks out a Gibson and buys a Gibson Les Paul instead of the PRS that musician had been playing in the smoky bar. Gibson said because of that, it injures their brand. It's really an absurd argument because Gibson winds up taking the sale. They're not financially injured by this. They don't lose a sale to PRS. In fact, PRS loses a sale to Gibson because of that confusion. Also, like I said, there was the stipulation that PRS made high quality guitars. So by buying either a PRS or a Gibson, it would still be a high quality guitar. And that's why you need to be careful when you agree to little minuscule details, because they could come and bite you. Also, and really the most important thing that the court said is this whole smoky bar scenario is ridiculous. The initial purchaser, the budding musician who went to the bar, when he buys that guitar, he's going to immediately know whether he's buying a Gibson or a PRS. There's no way for him to be confused. There are hang tags, there's a big old name on the headstock, there's a name on the case, there's a name on the receipt. He can just plain old ask. There is no possible way for any reasonable purchaser at time of initial purchase to confuse a PRS with a Les Paul. And because of that, the whole smoky bar scenario was seen for what it was, which is an absolutely stupid hypothetical. Additionally, the court in Gibson versus PRS said, yes, Gibson, you do have a trademark on the Les Paul silhouette, but that's all you have. You only get the vague outline, the two-dimensional outline of a Les Paul. And I like this decision because this is a case where the judge actually used a lot of common sense. The judge said there are any number of configurations of pickups, of knobs, of bridges, you name it, on the interior of that outline. And because of that, Gibson only gets the outline itself. Also, it's only the two-dimensional shape. It does not extend into 3 dimensions. And because of that, if anyone wants to make a single cut guitar, they can. It's also a case in which, again, the judge used some common sense, and the judge said there's really only so many shapes out there that you can make a guitar into. You can do the single cut design, you can do an S style, you can do a T style, you can do a V. Yes, there are all sorts of ridiculous shapes out there. I mean, the V is a ridiculous shape, and I say that as a proud V owner. Other than that, it is a very simple array of shapes. Ultimately, what this wound up meaning is that Gibson didn't have a whole lot that they could actually trademark. They got to keep the two-dimensional silhouette, and they also got to say no one's allowed to copy the headstock, because the headstock was where someone's going to be looking to differentiate. That's why you don't see anyone else using what Gibson calls the open book. No one else can use anything approaching that shape, and Gibson actually jealously guards that one, and frankly, no one messes with it. Gibson versus PRS, that decision ultimately came down in 2005, and at this point, it's 18 years old. We're going to see a lot more of this, especially because the Gibson versus Dean case is going to get appealed. And when it gets appealed, I think we can look to see Dean using the PRS case. And specifically, what they're going to use is they're going to use a doctrine called estoppel. They're going to say this sort of thing was litigated before, specifically with Gibson, and so they can't keep relitigating this over and over and over again. I wouldn't be surprised to see Dean use what's called estoppel, like I said, to say, hey, that decision against Gibson back then, use it against Gibson again now. And I think that's going to come back, and it's going to bite Gibson again. Of the claims in the Gibson versus Dean suit, the Hummingbird, that's a very strong claim. I don't think that Dean is going to be calling anything a Hummingbird anytime soon. They are going to take Hummingbirds off their guitars. I think you're going to see them stop using the actual words, the flying V, on their stuff. They may just call it the V. But I think they're still going to be able to keep their design with their different headstock using the PRS case. Again, the PRS case is the big Gibson case out there, and we haven't even begun to see the last of it. Thank you once again for tuning in. If you agree with me, if you disagree with me, if you have any questions, please leave them in the comments below. As always, I welcome your input. We're always going to have new content here, especially when it comes to legal news. And when it comes to legal news, you can better believe that Gibson's going to be involved. Until then, less fiddling, more playing.